140 words per minute for 8 minutes. 5 seconds more. Start. Invoking the writ jurisdiction of this court under Article 226 of the Constitution of India, the petitioner seeks issuance of a writ of mandamus for being appointed Inspector Prosecution in pursuance of the employment notification. It is the case of the petitioner that while the subject notification, the respondents had invited applications for filling up the posts of Inspector Prosecution and Sub-Inspector Prosecution from male, female and ex-servicemen against unreserved other backward classes, scheduled castes, scheduled tribes categories as per the criterion prescribed therein, and the total number of vacancies prescribed was 58, which vacancies were provisional and were subject to increase or decrease at the time of recruitment depending upon the requirement of the office administration. It was also stipulated that the candidates would be liable to serve anywhere in India in protection force and may be allocated to any zone after selection. Petitioner, who was an OBC candidate and met the eligibility criterion, appeared for the written examination after qualifying the physical test. Having been declared successful in the written examination, he also appeared for the viva-voce examination. The final result was published in the third week of August 2011. It is stated that though the final result came to be published, but it came to be published suppressing the merit list. Writ petition was filed by few of the candidates, including the petitioner, seeking issuance of a writ of mandamus to the respondents to consider the case of the petitioners if it was found that the petitioners were not selected due to a fault in the selection process, etc. In the counter affidavit filed, the respondents stated that though the said petitioners had secured the mandatory requirement of 60% marks in the written test and viva-voce, but could not qualify in the final list as the candidates securing marks over and above them were selected. Details of the marks secured by the said petitioners were disclosed in the said counter affidavit. This common writ petition came to be disposed of with the liberty to the petitioners to file separate petitions if they so chose. This resulted into filing of a separate writ petition by the petitioner. This writ petition came to be disposed of by the division bench of this court with the direction to the respondents to take a fresh decision keeping in view the aspect of vertical and horizontal reservations and the concept of interlocking. It was also observed that while taking fresh decision, the respondents would take into account whether the vacancies reserved for women OBC candidates had been carried forward to the next selection process or not, and whether or not a fresh selection process had been initiated. The respondents, however, declined the representation made by the petitioner, observing that all the 16 vacancies reserved for OBC category had been filled up by male OBC candidates and the life of panel had already expired, and therefore the petitioner at this point of time could not be appointed against employment notice. This has resulted into filing of the instant writ petition. In the counter affidavit, the respondents have stated that after getting the zone-wise details, the modified vacancy of Inspector Prosecution, including ex-servicemen, was 52. It is also stated that the 2 vacancies reserved for OBC women candidates were not carried forward and that 2 posts of Inspector Prosecution of OBC category empanelled on the said recruitment had not joined till date. It thus transpires that the respondents have not only ignored the ratio of the judgment of the Honorable Supreme Court in Jitendra Kumar's case, which clarifies the concept and the application of vertical and horizontal reservations, which entitled the petitioner to one of the posts remaining unfilled by a suitable woman candidate, but also refused to fill the vacancy when 2 vacancies were remaining vacant on the mere premise that the life of the panel had already expired in December 2012. Could the petitioner be refused appointment being at serial number 1 of the panel for no lapse attributable to him, for which the answer certainly would be in negative in the present factual matrix. On his part, the petitioner, getting to know of his merit position in the results declared sometime by the end of the year 2011, had filed a writ petition in March 2012. The said writ petition came to be dismissed, or rather disposed of, without a firm decision on merits, with liberty to file individual or separate petitions. This resulted in filing of writ petition shortly thereafter for the same relief. This writ petition came to be disposed of by order dated 5/2/2015. The said order adverts to the ratio in Jitendra Kumar's case that where adequate number of women candidates were not available under the vertical reservation category, the said posts were to be filled up from among male candidates as per the category of vertical reservation and were not to be carried forward. In the face of the law so laid down in Jitendra Kumar's case, it was incumbent upon the respondents at the very threshold of drawing the merit list in the year 2011 itself to do so. In paragraph 13 of the counter affidavit filed by the respondents to the present writ petition, in which it was stated that 2 inspectors prosecution of OBC category empanelled on the said recruitment had not joined. The petitioner was therefore under law entitled to be accommodated against the posts which had remained vacant, but this was not done. This lapse was squarely attributable to the respondents and none else. The rejection of the representation of the petitioner via communication of June 2015 was wholly erroneous. This is a case of lapse and fault of the respondents in not filling up the vacancies as advertised in spite of the selected candidates on the waiting panel. There is no justification and reason given why the selected waitlisted petitioner was not considered and offered appointment within the time limit prescribed for the panel. Wrong and faulty decision by the respondents time and again would not justify rejection on the ground of time taken in litigation earnestly pursued by the petitioner. The petitioner could not be accused or faulted for any delay. In view of the foregoing, the writ petition is allowed and the respondents are directed to consider the case of the petitioner for issuance of the appointment letter to the petitioner subject to fulfillment of the other terms and conditions of appointment in consonance with the employment notification to the post of Inspector Prosecution within 6 weeks from receipt of the copy of this order. Petitioner shall be entitled to the emoluments from the date of his joining, but notionally his seniority shall be reckoned as per the merit list. The pay would be fixed by granting notional increments when the petitioner would have joined in the normal course. Writ petition is disposed of accordingly with no order as to costs.